like you said, my name is Eileen Kendall. I am the owner of Kendall Law. I have been practicing law for so many years I can't count. I think it's like 18 now. And it's all been in the real estate world. I started my career in law school working for a real estate attorney, but when I came out of law school, I worked for a medium-sized firm in the South Bay called Spear, Woodward, Corbliss, and Goldberg, where we represented a pretty large national brokerage in the South Bay and working with their agents and brokers and getting deals closed, specific performance litigation. I think we even helped them with going through if they got subpoenaed on files and what to do with those. I worked there for 8 years. I have a year in between with somebody that I just have PSD about and don't talk about. And then I spent 5 years working for a national defense firm working for financial institutions and loan servicers in wrongful foreclosure. So I represented your Fannie Mae, Freddie Mac, your Ocwen, all your servicers, as well as the securitized trusts that all the things in 2012 got rolled into, trying to void mortgages. And that's where I got in the landlord-tenant space, because there's those mills out there that can do your standard evictions. But once they become contested, they don't really know what to do. And so the servicers would pull them and send them to us, and I started doing those contested evictions. You know, I had one where somebody said that they had rented the place from the owner, and it was some guy on Craigslist that didn't even own it and entered into this lease, and you have this squatter in the property. So things like that, and that's how I kind of started my landlord-tenant my work. I went out on my own 5 years ago in October. I now have a staff. I have an associate that handles evictions. I have a paralegal and a legal assistant that help me, because this is what I go out and do, and then they go and do the work. That's the hope. I had trial this afternoon. I've been trial all week. Actually, it's been going on since November. But I would say that 75 to 80% of our practice is landlord-tenant, and it's a very volatile area, and it's constantly changing. So what I'm going to tell you today is in place today. Come February 1st, it's probably going to be different. The eviction moratorium in LA County is supposed to end January 31st. I don't have a crystal ball, and I always want to be hopeful, but with the spike, I'm going to assume that they're not going to terminate it. It's interesting, I'm getting conflicting information about LA City's rules. There was a tweet that went out towards the end of the year that said that 2 of the proponents for the LA City rent freeze and eviction things that happened with the city were not going to push it forward. They weren't going to vote for it. Well, LA Housing Department has a whole thing on their page that things are changing, and you're probably going to be stuck till 2023. So we're researching that, and we're trying to get accurate information. So today I'm going to tell you that what I tell you is probably true today, but may not be true tomorrow. And it's always advisable, if you have somebody that is looking into getting a property that is in the rental space, to have them talk to somebody first. Don't buy and then talk to somebody, because the problem I get is somebody that buys a property and has no idea what they're getting into. Then they call and say, I want to evict these people. Oh, well, you're in LA City and it's going to cost you $20,000 and you have to go through this, or you have to go through that, or whatever it may be. So it's always best to tell your buyers to talk to somebody before they get into it. So you mentioned looking for a multi-unit in Santa Ana. So I'll start with Santa Ana. On November 17th, Santa Ana became the first city in Orange County to fall to rent control. They now have rental protections and laws in place. I think it was November 17th or 19th, where you have to have just cause and there's rent caps. So just be aware that in that market, you're now not free reign like it used to be. You guys are in Long Beach, so I'm just kind of going to touch some of the new laws real quick. Long Beach. I don't remember the effective date, and it's kind of stayed. You cannot terminate a tenancy right now at all for substantial remodel. And when they do allow it, which I think is coming in a few months, it's just not been signed off on yet, is now there's going to be relocation. I don't remember, and this is one of the reasons why I'm going to have you guys follow me, is I push these things out in mailers. You're going to have to pay a certain amount of relocation. I think it's like a certain dollar amount or 2 or 3 times the rent for that to do a relocation. So those are 2 of the main landlord-tenant ones. There's a bunch of other things, like there's new disclosures. January 1st, if you have people that are in property management or no owners that are have rentals. January 1st, there's a new disclosure that needs to go out to every tenant, and it's a mold booklet. So those new disclosures are required. There's going to be changes in the lease agreement. So you want to make sure that if you have any clients in that space already, not just buyers, that they're making sure that they're getting updated information, they're providing any new disclosures, they're using the correct form. I get people that come to me, I want to terminate a tenancy, and then I look at their lease and be like, you don't have any of the right disclosures, because they've used something that somebody gave them and haven't checked to see. I go to the apartment association, California Apartment Association. That's where I go to get all my information. I'm a member because I did have a rental in Long Beach at one point in time. I now sold it and moved out of California. I always say that I can put myself out of business. I would not recommend anybody to ever be a landlord of a multi-unit in California. I even backed out. I went to Arizona. But then that puts me out of business. You just want to make sure that your clients and people that you're working with are using the most accurate information, because as the laws are evolving, things are changing. So in 2019, the Tenant Protection Act went in place for anything that was 2 and above in the state of California. And as a part of that, owners and managers were supposed to give certain disclosures by, I believe, September of 2019. But there was nothing ever said about what if you didn't give them or how you do it. New leases now should have that as a part of it. But I'm finding that these moratoriums and these changes say you can evict for owner occupancy, but only if you gave that disclosure as required. And you have owners that never did that. So I'm like, go do it now. You better better late than never, and then we'll try. Because it does now have a statement. Single family, as long as you gave those disclosures, and that's a change. So if disclosures have not been given, then you need to go back and give them, just to be safe. So I always say, you need to make sure. There's a lot of people just do it on their own and just don't know that they should be talking to somebody. So here we are in COVID. I am busier than ever right now. January 1st came, and all of a sudden everybody wanted to see what they can do. The statewide eviction moratorium ended on September 31st. So for any properties outside of LA County, because we'll boil down to LA County and then LA City. So we're going to start with statewide. Statewide, as of October 1st, if your tenants are not paying rent, they can terminate the tenancy for non-payment of rent. There's a new 3-day notice. There's some requirements of the owners to go through and apply, which they didn't have to before. It was on the onus of the tenant. Now the landlord has to apply before we can start the eviction process. And then any of the other county exceptions are gone. So if you have any properties outside of LA, and I'm only talking about Southern California. I don't know anything about Berkeley and anything like that. So if you're in a city that is not subject to any tenant protections, then you can evict for cause now, or without cause. So if you have a single family, because that's the question I get from realtors all the time. I have somebody that wants to buy a house, but it's tenant occupied. Well, where is it located is my first question. If they tell me it is in San Bernardino, it's a single family, you can sell it and you can, remove the tenant. If you're going to tell me it's in LA County, there are allowable, that's the only allowable way. Anything other than LA County, you can terminate without cause if it's not under the Tenant Protection Act. So you always have to remember there's this Tenant Protection Act for anything 2 and above. Duplexes that are owner occupied are exempt. Single families are exempt. Condos are exempt. So now let's talk about LA County. So LA County is a plethora of a mess. There are several cities that have their own Tenant Protection Act. There is the newest city, it's either Hawthorne or Inglewood, that now have a Tenant Protection Act that went into place. And then I have on my website, I'll tell you to follow it, there's this information. There is different requirements. So that is always the first question I ask is, where is your property? Because the relocation. So you have somebody that wants to buy a duplex and wants to owner occupy. In Torrance, you go through the county. And under the county, you would be able to, even right now, terminate for owner occupancy as long as that disclosure was given for the 2020-19 Protection Act. But under the eviction moratorium that's in place, there is relocation. And if it is a city that is not governed by a Tenant Protection Act that gives a relocation amount, the relocation amount goes by the unincorporated cities amount. So in April of 2019, you have your LA City RSO properties, right? Everybody kind of knows those. Those are those ones that are in San Pedro, kind of Santa Monica, just different places in LA City. Well, unincorporated cities, there's 72 of them now also have a Tenant Protection Act, and their relocation's insane. It is like these amounts, and you have to pay for packing, and you have to pay for moving, and you have to pay for putting in utilities, and it's based on a formulation. The landlord has to go to this relocation specialist, and this relocation specialist will determine the amount of the relocation. Really? Okay. So it is very confusing. That's why I always say, I'm kind of just glossing over the big terms, is if you have somebody that's going to go into one of these cities to check if there is something that governs the tenants, because California is extremely tenant friendly. But even in Torrance right now, if you want to remove a tenant, even in a single family or a condo for owner occupancy, you have to go and pay this relocation that's under the unincorporated municipal code for this new tenant protection. You have to attest that the tenant is not suffered from financial distress from COVID. You have to attest that they're current on their rent, and the new owner has to live there for 3 years. And the form even says we have the right to go spot check to make sure your owner is in there for 3 years. Again, supposed to end January 31st. Probably not. It's probably going to be extended. So in LA County, the only way you can remove a tenant right now is for owner occupancy, and you have to go through all these loops. Under LA County, it goes the same with the state. Is anything after October 1, you can do a 3-day notice to pay or quit. It's a special kind of notice, and then you can proceed with the eviction process as long as you go through and try to apply for rental assistance, and the landlord, either the tenant gets denied or the tenant doesn't do what they need to do within 21 days of the application. We just check boxes, it's verified by the owner, and we proceed on. The courts, what's happening in the courts is once we file, the tenant comes yelling and screaming, I have COVID financial distress, I have COVID financial distress. We have been able to defeat those. My associate went yesterday, and the tenant's request was denied, but basically the court stays the case pending the outcome because he late filed. So we don't have to start over, we just have to wait to see what Housing is Key does with the application. So at least we're putting the feet to the fire for these tenants, because a lot of tenants, they're just milking it and then they're not doing it. You're getting the opportunity for free rent from the government, why not apply? But they don't. But LA City is a totally different. So when you think LA City, it's not just an address that says Los Angeles, San Pedro areas. There is a website that I go to. I can't name all the cities. I always go to this website. It's called, I think it's zimas.la.org or something like that. Anyway, it's Zimas. If you type in ZIMAS, it comes up with this. You put in the address. If it says no address found, you're not in the city. If an address comes up, you're going to get a thing on the side that gives all these statistics. You hit housing, and it's going to tell you whether it's RSO, whether it's under the Tenant Protection Act, and whether or not it's an Ellis Act property. That's the first thing I do anytime anybody calls me, because I definitely cannot tell you what properties are what off the top of my head. I even have a PDF on my desktop for the unincorporated cities, because I have no idea. There's 72 of those.
Quick question,
Yeah.
just to clarify, is RSO
Rent stabilization ordinance.
Rent stabilization.
Mm-hmm.
Okay.
And those are the ones from like the 1970s. The other ones, the unincorporated does call it unincorporated rent stabilization ordinance. All the other ones are more or less called like tenant protections and rent caps, but everybody just says RSO. So you just kind of take it as being governed by what you can do with rent caps and evictions. That's all it is. But the two for LA City and the unincorporated cities are called rent stabilization ordinance in the LA Municipal Code. In the city right now, there are no rent increases. And that's the conflicting information about when that's going to go away. Some people are saying 2023, depends on when the emergency ends, because the way it's read right now is it's 1 year after the emergency ends, or no later than March of 2023. So it's evolving, it's changing. They make some revisions every single time. You cannot terminate tenancies for any reason in LA City, including non-payment of rent. For the non-payment of rent issues, it states that the tenants have 1 year to repay the rent after the eviction moratorium is done. Now, again, this is where you get conflicting information from the LA City's tenant-friendly page versus what the statute says. Is the way that we read the statute is for the time period of when COVID began to September 30th, they have no later 1 year to repay the rent. However, that repayment starts in March of 2022, which makes it they have to repay it by March of 2023. It doesn't start then, but it ends, they have to pay it by March 2023. For the rent that became due October 1 until the end of the eviction moratorium, this is the part, is they have 1 year from when the eviction moratorium ends. Nobody knows when that's going to be. So properties within the LA City rent stabilization ordinance, excuse my language, are screwed. There's nothing you can do. We push the envelope sometimes if you have reason to believe that they have not suffered COVID financial distress. You know that they're going to work, they just have a new fancy car, they're going on fancy vacations. You can serve a 3-day notice, but you're probably going to get a nasty letter from HICDLA saying this is an illegal eviction, and all you have to do is pull it. Or you can argue and push the envelope and say they're not suffered from a COVID financial distress. There's a problem in California is a landlord and owner have to accept the statements of the tenant. So in New York, and I have a friend that does appeal work, and I asked him if he would take the leap on this, is in New York, cases were appealed and the Supreme Court ruled that for New York's moratorium, a landlord had the right to challenge the statements of the tenants under due process, because it's a violation of due process just to accept their word and no way to challenge it. But California doesn't have that. So that's kind of a nutshell of, because usually questions are better because it gets into more of your concerns. It's a nutshell of where we are. February 1st, what I told you could all change. But I don't know. And it might be minor changes. My hope would be that it goes away. But again, with the spike of numbers, I highly doubt it, especially because we're getting notices from the court saying that things that we're able to be doing in person are now back to virtual. So I will open the floor for questions.
So hypothetically, we have a buyer in Long Beach who is looking at duplexes and wants to own or occupy. Now you're saying they can evict tenants as long as this disclosure was provided to them, and is that by the current owner or the person selling the property had to?
Yes, yeah. So the lease agreement, depending on what it was, is hopefully all the disclosures were given. And part of that is depending on when the tenancy created, like CARS form and California Association of Realtors form, or what is it? But the Apartment Association's forms, as of late 2019, included those disclosures. So it just depends on how long of a tenant. If it's been a tenant that has been there 20 years, and I'll just say that there are some cities that if you have a tenant that's been there over 10 years, you'll never be able to get them out. So you just have to check on the cities. You should have given that disclosure. So if the owner hasn't, you need to check and have the owner do it. That way, by the time you close escrow, that disclosure's been given. The new buyer is the one that will have to start the eviction process. And while Long Beach is, because Long Beach is under the county, then you have to still do, as of right now, this consumer affair declaration by the owner that wants to own or occupy. And basically it has like who the name of the tenant is, how long the tenants live there, what the rent is, who the new person's going to be living in, what that relationship is if it's not the same person. So like if you're moving your mother in. The one thing I forgot to mention is the person that you're removing, the person moving in has to be similarly situated. So if you have a 62-year-old, let's just say a 70-year-old, so they're a protected class as an elderly person. The person moving in has to also be in that class. If you have a handicapped person, you have to have the person moving in be there.
Even as the owner has to be like as...
Yes,
as
you cannot terminate the tenancy of an older person if you're moving a 20-year-old in. So there's that requirement too. Again, these could be changing, but that's the way it's written now. And then you have to pay relocation. Long Beach does have some relocation numbers. So because the law is as clear as mud, I would say that you could probably use the relocation for substantial remodel, which is incredibly less than what LA Municipal Code would tell you relocation is. Because the way it works is you have to pay relocation amounts pursuant to where the property is located. However, if the property is located in a place that does not have relocation requirements of any kind, you have to abide by the LA city or the unincorporated city's schedule. And because Long Beach, I would argue now has relocation for substantial remodel, why not try using that number? Can't guarantee it'll work. And that's a lot of what's happening right now is a lot of, let's see if this works, because there's no precedent for a lot of these things. And if there's reasonable enough grounds, I am willing to push the envelope. But I explained that you could get a nasty letter and you'd have to revoke it.
So I know in, like you said, the city of LA, the relocation is like 17 to 20,000, depending on various factors. In LA or in Long Beach, in the past, we had done relocation and it was 2 to 3 times rent, I think. Is that what it's similar to?
Yes, that's what I believe even for the substantial remodel. But substantial remodel said 2 to 3 times time rent or 4,500, whichever is greater. So it depends on what it is.
Okay, but there's no recent history of how COVID has affected that, and if that is...
No. There's no... Long Beach, and I checked recently, theirs was repealed a while ago. That I don't know that Long Beach has any COVID moratoriums. I think that they were going under the county. Mm-hmm. And because the county now allows you to evict for any reason, for owner occupancy only, then you would have to just do it by the way that the county is governing it.
Okay, so here's this. Oh, go ahead, Debbie.
No, I think she had a question, but I'll let you finish.
So a scenario that I have a legal duplex with a bootleg unit. It's been that way for a long time. I bought it that way in 2006. The tenant who was in the bootleg unit has lived there for 21 years, and she is probably over 70. She's COVID affected, so in 2019, I said, hey, we need to get caught up by 2020 or we'll have to have a conversation. Didn't happen. I continued to keep her on. She's currently about 6 months behind in her rent, but she worked in construction, so she just isn't getting hired because of her age. And so now I'm going to sell the property. I'm going to sell it with her and the apartment above it occupied. The front house is going to be empty, vacant, right? So the presumption is a millennial moves in the front and inherits them. Will they be able to evict, or how would that affect as far as the 70-year-old protected class?
Right now, as we sit here now, no.
So I'm the third owner. She's lived there longer than I'm the third owner that's been there since she's been there. Mm-hmm. So as far as what she's been given, what leases and stuff, it's very muddy, obviously.
Mm-hmm. Yeah. So with the eviction moratorium in place, no, because you won't have. The only way you can terminate a tenancy anywhere in LA County right now is for owner occupancy. Well, the owner is going to be living in the front unit. They can't. Well, I should say that they did revise it to say if you have another, you can do 2 properties if you have a duplex or triplex. So if they have a brother that wants to move in, but if she's compacted and she's elderly, nothing there's.
How does the non-conforming unit play into it? Because I know that now they've kind of with the ADUs and they've
so
amnesty.
that's a sticky situation because the only way to really make that happen is to report yourself and say that I have an illegal unit and have the building department come out and red flag this and say that it's health and safety or doesn't have this, or because that, absent the eviction moratorium, one of the just cause evictions that are allowed is by government order. So if you have the building and safety come and say, this can't be occupied, you need to terminate this tenancy, that's grounds for terminating the tenancy under any of usually the rent stabilization ordinance properties. But that gives you grounds to terminate the tenancy. You can't terminate. Well, you can terminate now for non-payment of rent if you go through all the steps. You give them the notice, she applies, she gets denied, but you have to go through that process, and most likely what's going to happen is she's going to get approved and you get paid, so you can't move on that grounds.
The protected class isn't affected in that scenario?
Is it Long Beach still?
It's City of Long Beach, and I believe she's over 70, real close to it.
It would only come into play as if the person you wanted to do owner occupancy, at least right now, because I'm not aware of Long Beach having eviction protections for any class.
Okay.
You had a question.
So you said she would have to apply and then be denied. How long do you have to wait?
So the way it works right now is if you want to start an action for non-payment of rent and you can't get the tenant to apply, a landlord has to apply. But the tenant has to do their part because that's what it's based on. The way we are right now is you wait 21 days.
It's only 21.
21 days. If the tenant doesn't do what they're supposed to do, you then sign off, and there's a form that's provided by the court. You check off, you sign under penalty of perjury that this is when you applied, that there was no response. You provide a printout of your, it's Neighborly, I think, is the app, that the software that they use, that basically says non-responsive. You attach it as exhibit and you file it. Then the tenant gets served, and the tenant comes yelling and screaming, I applied. What I'm finding there is a lot of times tenants apply and don't do what they're supposed to do to get the landlord on. So you just call Housing is Key with the two numbers, the number of your application, the number of the tenant's application, then they're combined, and once they're in process, then you just have to wait. If it's denied, then you can proceed, but if it's in process, you can't move forward.
Oh, so 21, because I have a tenant, she's not behind, but she applied October 1st and still in process.
If it's in process, you just have to wait. It's only if it's non-responsive in 21 days. Because Housing is Key is taking anywhere from 120 days to process these.
Housing is Key, that is the
That's
website?
Housing is
Housingiskey.ca.gov.
something like that. Just type in Housing is Key. There's big billboards everywhere.
Yeah.
Because all tenants should get free rent, even if not needed.
So I have a friend that is renting a house in Lakewood, and he called me, and he said he was supposed to be out by the end of the month. He wasn't, it just was that they want to sell the house. Are they allowed to do that right now?
Theoretically, no. Unless the new owner is going to owner occupy, and the new owner is the one that would have to start the eviction process. Now, I only represent landlords and owners. I don't represent tenants. But in that circumstance, I would have pushed the envelope and I would have served the notice saying that this is an exempt property and you need to get out. And then maybe if I'm lucky, they get out. And if not, they challenge it. And then we just do a cash for keys and get them to move
What
out.
happens if they weren't given those disclosures?
If the owner files an eviction, those are all just affirmative defenses that the tenant can bring to stall the move out.
They didn't file for an eviction. They just give her 30 days
Yeah,
notice.
but when he doesn't move out at the end of January, that's their next step.
Oh,
If they really want them out, they're going to move forward based on that 30 or 60 day notice to terminate and file an eviction action. So the tenant, in response, will file an answer with affirmative defenses that it's, and depending on if they do it themselves or they have these tenant attorneys, it's a pre-printed form that they just check boxes of all the affirmative defenses. And there's a whole section about a violation of the moratoriums. And they'll just check all the boxes, and then a court will decide.
So is the rule still in effect that if they've lived there more than 2 years, or more than a year, that they still have to give 60 days notice?
Yes, absolutely. So it's always a 60-day notice for termination based on no fault termination if it's 12 months or more.
Okay.
So I keep hearing different points of view on this. So the 60-day notice, some agents say give it at time of listing, some say give it at time of opening escrow, and others say give it at time of closing. What does the law say?
Nothing. The law doesn't say anything. So typically what I tell people that are in escrow is you want to serve the 120-day notice of sale so that they know that it's up for sale. Obviously it's easier to sell when they're gone. So like with my rental, I just told him, hey, I'm listing it just to let you know. We coordinated for showings, and I worked with him and gave him the 60-day notice before we even opened escrow so that my realtor could show my place empty. So I would say that timing wise, I would do it as soon as you think you're going to sell.
So as soon as you have the listing, give the notice, and there's no liability connected with that as far as the tenant getting legal counsel and saying you could give.
The tenant, if they were going to.
Well, I mean, in a battle in court, where would that end up?
So right now you can't do it. So you would lose because under the eviction moratorium, you can't terminate for anything but owner occupancy, even on an exempt property. So in LA County, typically, if you have a condo or a single family home, you could just terminate on a 60-day notice and not give any cause. However, under the eviction moratorium, those are included. So the only way you can terminate a tenancy right now in LA County is for owner occupancy. And that is required after the close of escrow, and the new owner is going to be the one that starts it by doing it for owner occupancy. Prior owner can't do that because they're not the owner that's going to occupy.
So you can't give notice then when you open escrow? So if you open a 60-day escrow, could the tenant or the landlord?
So you can't start an eviction if you're not the owner.
Not eviction, just the notice part.
Right, but then
Okay.
you can't proceed.
The eviction can't happen until the buyer takes possession.
Right, and the person giving the notice is the one that's going to have to say, this is being terminated for owner occupancy. Well, your owner's not going to occupy it because
Okay, so it's a poker match. So you take the listing, you give the landlord gives the notice, crosses the fingers, hopes that they just look at it and say, okay, I got to go, right? And then everything happy ending. If they get to the end and there's more research and they just say, I'm not going anywhere, close escrow. Now it becomes the buyer's issue, and the buyer says, okay, now we're going to start that 60-day over again. And when we get to the end of that, then you start the eviction process,
Correct.
which is probably another 3 months.
And so on those transactions, what we're doing is we're advising if you're representing the buyer, is that if you can't get it empty by the time they move in, there's going to be an addendum or some concession, because I have clients coming to me that have $20,000, $25,000 still in escrow after close to pay to get these people out. So once escrow closes, either there was a reduction in the sales price for them to do it, but a lot of times what's happening is the seller is agreeing to hold back a certain dollar amount to pay the relocation or the legal fees associated with removing this because they couldn't remove them ahead of time. So that is part of a transaction negotiation that's happening when you have these properties that the buyer wants to live in.
What would be the typical legal fees, typical to worst case scenario?
An average case is about $5,500. So far, my worst case scenario has been $40,000.
And if the buyer is getting a loan, the lenders generally have a 60-day, you can only let the tenant stay there for 60 days and then you have to move in.
I don't know anything about that part. I think he had a question.
That was my question about the 60-day for the lender.
Yeah.
If they don't move in, it's fraud. If they know that it's not going to be, they can't move in within 60 days, and they go ahead with the loan, it's fraud.
Because you're getting the loan as an owner-occupied
Correct.
property.
Yeah.
Yeah, I think I've had that question before, and what you think the bank's really going to check on that? And as long as you show in good faith that you are trying to remove them and they're being jerks and they're hiring tenants counsel,
And you pay your mortgage.
Well, it's not fraud because it's all about intention, right? So if the
Right.
buyer bought it thinking that they were going to occupy it and
Then
circumstances,
rent it out. That's
yeah,
where I say
circumstances
you're
beyond their
concerned. But
control.
If you're taking all the steps of trying to remove them, you know, all somebody would have to tell the bank is it takes 6 months to get this through the court system, and they wouldn't move. And I don't think that you're gonna be. I don't think you're gonna have a note called for that.
Yeah, especially if you're making the payments. The last thing they want is to deal with a
Right.
foreclosure. Or
My question is there any rights of the tenant to not allow either like showings or inspections or anything like that when a property is
So, as far as I know, unless things change now, because there are certain health orders that are going in place, like employees now have to provide medical grade masks, and we're not going to be able to use cloth masks. Prior, it was under the health order that they could deny access. Under the current order, you can get access as long as you're complying with all the COVID regulations, you know, the social distancing, the masks, the cleaning, etc. The thing is if they deny access, say they have an immune compromised child or they have whatever, you can't terminate the tenancy based on their refusal. But you should be able to enter.
so to the point of, let's say locks have been changed, you can enter. So you've given them their 24-hour notice. You complied with all the COVID regulations. You show up. They're standing at the door saying you're not getting in. Door's locked.
Nothing you can do about it.
Nope,
okay.
Even with cops there. I've been there.
Nope, can't do anything about it.
No,
They're going to
can't.
refuse access. They refuse access. In old days, and maybe one day again in the future, you could do a 3-day notice to cure or quit that lease violation, but you can't do that right now. I mean, I still serve them, but you couldn't file an eviction based on that.
Are there any differences under the law in terms of if for some reason the seller squats after close of escrow and does not leave the property and you're trying to get them out?
Yeah, so the definition of squatting, you know, it's a squatter's notice. It's a 5-day notice, and basically you're there without authorization. So I liken it to the foreclosure process. So in foreclosure, if the seller doesn't vacate and you have, or if there's still an occupant after foreclosure, you serve the 3-90 days. And what that means is the prior owner needs to vacate within 3 days. Or if you provide a valid lease that shows that you're a tenant, you have 90 days. So I think that I would probably make it in where I'm doing that, because they're not really a squatter. A squatter is somebody that forces themselves in unauthorized to start with. You know, for instance, I have one pending that's going to trial next week. Bellflower maybe, somewhere in Lakewood area. Single family home owned by the uncle. Nephew lives down the street. Uncle dies suddenly, has a heart attack in the front yard. Nephew grabs the keys out of his pocket and moves himself into the house. He's a squatter. We're suing him to get him out. The estate's being probated. They need him out. So that would be a squatter, somebody that's illegally gained access to the property. So I think that you have an owner, and there's been several articles in news that it's going to be a crazy long battle, because they're like, I'm going to stay, and there's enough cases out there that people are doing it and milking the system. But I would do it as a 3-day, 90-day notice like you would in a foreclosure.
Does probate change anything
No.
on any of the laws or how things are?
No, because you're just being, like, I represent a private fiduciary. So I get all of his nasty, you know, cases. It's just the matter it's being brought by the estate. Where there's a question of title, the only really extra step is I get certified copies of title, because that's one of the defenses they like to bring, is you don't have standing to bring this. So I get certified letters of administration, or the certificate of the trust, or, you know, a certified copy of the recorded deed transferring the property to the new owner, because that's a common one that they like to bring. Because legally, really, property management companies are not even allowed to bring these cases. But there's enough out there that says, as long as the property management agreement says that you have the right to bring these cases in the name of the owner, but it's unsettled law, and it's a thing that they always bring up in defense is standing.
So the disclosure you mentioned, is that the one where this is a SFR and it's exempt from rent control?
Yeah.
Okay.
And if you use CAR forms, I don't remember the initials, but it's been revised slightly over the time because mine was slightly different to the recent one. But yeah, if you use CAR's forms, you just type in rent cap or just cause, and that addendum comes up.
Yeah, it's like JDSU or
Yeah,
something.
something like that.
Is it retroactive? So if so, I've got a scenario. Buyer is putting an offer in on a duplex. The owner of the property had passed away. It's being probated. The father is taking care of the estate. So he says, I don't have. We are trying to get estoppel information and leases and the debt. I have no record. I have no idea what my son did with it. So obviously, there's no knowledge whether these have gotten served or not. So then it just becomes a he said, she said, and the tenants, if they're wise, they'll say, I never got those disclosures. So can they now be given by the estate?
I don't think I would, because that muddies it. Like, because if we can do a document demand and get all the documents from the other side, I think that you're going to have a little more. You're just going to base it on a month to month until you can get the documents that the rental agreement has been lost and stolen. I mean, I suppose as a safety measure you could, but you don't know anything else about,
But was there a drop dead date? I mean, can any of us
Yes,
as
I mean,
landlords go and
There
say,
was a drop dead date of September of 2019 that all people were supposed to give that notice, and then any new lease entered after a certain date needed to have that disclosure.
but if none of that was done and somebody said, oh my gosh, I better,
I just tell them to serve it.
okay. But it's, once again, it's kind of a Trojan horse.
Yeah, I mean, it's. I'd rather serve it now and be able to say, oh well, we served it. And, why was it served late? Well, because this, and this, or we don't know if it was, so we served it.
Got it. And once again, you're putting that knowledge in front of the tenant and hoping that they just read it and, okay.
Yeah.
And I have a comment, not a question, but I was listening to an interview with a property manager, and if you get the squatter, you call the police, you don't use the word someone's trespassing or squatting, you say they're vandalizing, and otherwise, then that's why the police would show up for vandalism.
Yeah, a lot of times the police is going to show up and they're going to say, nope, this is a landlord-tenant matter. I can't do anything without a writ of judgment. Whether they would do it if you said vandalizing, they would come out and, in one of the foreclosures I had in my other practice, it was out in Redlands or somewhere, and they had turned on the utilities in their name. They'd done everything, and that's all they have to show the cops is, I've had my utilities are in my name, and the cops gonna say, oh, that's a civil matter. You need to go do an eviction. You had.
Yeah, I wanted to kind of piggyback on Gina's question about the squatters. Past couple years, we've had a lot of rent backs included in transactions where the seller stays back 30, 60, 90 days. Are all the same protections in there for tenants as far as moratorium and evictions and all that when you have a rent back lease?
Yes and no. So what I would say with that is, if you're getting into those, please talk to somebody about having the right language in them, because the way that I would handle that is not as a landlord tenant. It is as a contractual agreement to vacate by a certain date. And the note, when you're doing the addendum or when you're doing the form for the seller staying back, that you need to make sure that you're including something that no further notice is needed to bring an action for possession. Then as soon as that date ends, because one of the ways that you can terminate is if somebody has said, I'm going to vacate by January 31st and signs off on it. February 1st comes, they don't move out, I'm not serving a 3-day notice, I'm not serving a 30-day, I'm not serving a 60, I'm not serving anything. I'm immediately filing a lawsuit because there's this document that the tenant said I was going to vacate by a certain date. And that's one of the benefits of like a cash for keys is, in my mind, legally that changes the scope of the case. If you negotiate a cash for keys and you say, I voluntarily agree to move out by this date, I'm getting 50% now and I get 50% on move out. When they don't move out, I don't have to do it on a 60-day notice. I don't have to do it on anything. I do it on the failure to move out on a specific date. There's a box in the eviction complaint that says didn't move out on date specific.
Does it matter that you gave them money up front, or do you?
So now what they allow is a part of your complaint, you can get recovery of the money that you paid.
No, I mean, is it considered, you have to give them money up front for
No,
it to? Okay.
I just advise it because a lot of times when you're doing these, you have a tenant that has been there a million years, is under market, and can never afford to move out. They're hindered. If you want them to move out, you don't want to give them all of it, but give them something so that they can actually move out. Because the two things tenants want, more time and money to be able to pay the first and security deposit for a place. Because most of the time they can't.
Does rent forgiveness count as relocation if somebody was behind $6,000?
Yes, absolutely.
Okay.
We've done lots of those as and all of the settlements in evictions that are pending, most of them are either an agreement of a waiver of the back due rent, or you need to comply with housing is key so that the landlord gets paid. So we write that into our agreements, is that the tenant will comply and cooperate with housing is key. It's like a waiver, the government's gonna pay. But if the government doesn't pay, then the tenant still doesn't pay. So absolutely, it's a valid way to work these out, and a lot of them are being done that way.
So if they were behind $6,000 in the rent and you made an agreement that says, we're waiving that and I'll move out by January 31st, then that becomes that agreement that you can file a lawsuit. You don't have to worry about the eviction and all that.
Well, it's still an eviction lawsuit. It's still under the unlawful detainer because you want it to go fast. But it's on a different, so when you look at an unlawful detainer, it says 3-day notice to cure, 3-day notice to pay, 60-day, 90-day, other. Or no, actually there's a box that says at the expiration of the agreement or whatever it is. So there's a box that's actually checked to say that this is being brought on these grounds, not these other grounds.
So scenario, mom and dad and daughter move in. Daughter's like 17.
Okay?
5 years later, daughter gets married, daughter's husband moves in. Do you have one tenant or two now?
Was mom still living there?
Mm-hmm.
So those are what I call, well, okay, I should ask. More specifically, is there a rental agreement?
Month to month with mom and dad.
So the daughter is paying rent under an agreement.
The daughter, no. Just mom and dad. Collectively, they are.
Okay, so I'm sorry, I thought you were asking if whether mom and dad had a tenant. So mom and dad are the tenants. Their daughter moves back in, husband moves back in. As the owner, you now have 4 occupants, but only 2 or 3 on the lease. What I recommend in those is you need to get a new updated lease, and you need to show that, because what happens is you don't usually have it when you have that many people. But the cases that I see are coming in are mom living in the property. I have one of these right now. Mom living in the property, adult son is living in there, mom dies. But there's nothing with the son. So I'm terminating that on something called an at-will tenancy that can be terminated upon 30 days of notice of death. He's yelling and screaming saying, I'm a tenant. We're saying, no, you were asked to come and stay. There was no rental agreement with your mom. You didn't pay your mom rent. My client didn't accept any rent. You need to go. So we're litigating it, and we have a jury trial set because he's going to say he's an authorized occupant, but it's not in the lease. A lot of times you see these in caregiver circumstances. In-home care, person dies, in-home care doesn't want to leave. They need to go. They're at will. They're there as a part of the owner's request. There's no rental agreement to pay rent. So it's what we call an at-will tenancy that can be terminated upon 30 days of death. In that state, is the owner, if the husband can prove that he paid a portion of the rent, then he would be considered a tenant. If he can't prove he paid a portion of the rent, then I would say he's probably an at-will tenant of the parents or the daughter, and that he could be terminated at an at-will tenancy.
Okay, so out of respect for time, I know you need to get going. If there is, as far as fees goes, if there's a non-contested foreclosure.
So if you hire my office, it is a $5,000 retainer. That money sits in my retainer if used it gets used. If it's not used, it's refunded. The $5,000 is about the average cost to get it from start to a uncontested or even just a plain court trial. It is increased to $7,500 if a jury trial is demanded, and I bill at $4.25 an hour. My associate bills out at $300 an hour, and they vary depending on how cooperative the tenant is, if they have good counsel and we can get a settlement, versus they make a jury demand. The one that cost $40,000, we didn't even go to a jury trial. I won on a motion for summary judgment. And then for every single day up to the lockout, they filed some kind of crazy motion that we had to deal with. We had 5 sheriffs have to come to the house to remove them. And they were still fighting it every step of the way, even though we had won. So worst case scenario, it can cost $40, $50. Usually it costs between $5 and $15.
And then initial consultations, we refer you to a client and they call just to
Yeah,
ask.
it's a half hour for $210.
Okay.
I'll tell you, most of the time in these, consultation is probably not needed. If you have something, they usually, I just have my assistant ask, you just want to hire us, this is how much it costs.
Mm-hmm.
You know, but if there's funky situation where there's a need to walk it through, but if it's a straightforward one, sometimes I just tell them to hire me, you know.
And then if somebody wanted you to complete paperwork for rental assistance, that type of thing, it's just the same billable hours?
Yes. You know, and I've only done it for one client. Everybody else does it. Nobody wants to pay
Pretty
me to
simple.
do- Yeah, it's just going on and creating the profile and uploading the documents. It took me about, well, I didn't have his W-2, so it took me a little longer, but I said if I had all the documents, it'd probably take 5 minutes.
Okay.
I mean, and that it's just a property that he just has me do everything. And I didn't even want to apply. It's a $10,000 a month rent in Beverly Hills, and he's not going to qualify, but before I can evict him, I have to do it.
So before I close this off, go ahead and your name, your firm, and your contact information.
Yeah, so I am Eileen Kendall. The firm is Kendall Law. The phone number is 310-619-4941. I have cards, pens, and little post-it note there that has my contact information. I am going to get a mailing list. You'll get an email from me thanking you for coming so that you can follow me on Facebook, Twitter, and LinkedIn. I do a monthly blog post, mostly landlord-tenant work right now, but it varies from month to month on what it is. And then, like when Long Beach changed the law, I sent out a mailer just on that. So I do periodic updates as things change. Beginning COVID, I was sending out something almost every other day because the changes were so big. So.
You just do regular landlord tenant, or do you go there kind of real estate?
So I do real estate litigation.
Okay.
I represent, like, I am in-house counsel for another brokerage. I am counsel for lots of property management companies. I do risk management speaking at the South Bay Association of Realtors. Non-disclosure cases are my, those are the dream cases because those are the big ones. So landlord tenant, I'd like to deny that it's such a big part of my practice. I did it because it's easy to market and people understand it. So when I went out on my own, that's what I got. And people love me. So my practice has grown to more like 80% of my cases are landlord tenant. That's why I got an associate.
Where's your office?
In Torrance.
Awesome. Thank you very much.
Oh, you're very welcome. Thank you.